one of the most exciting and intriguing things I get to do is working with individual first-time inventors. And so I put this speech together for them and for you if you have that in your mind. I want to encourage you to think about innovation. And even if you don't think of yourself as an inventor, I encourage you to take that step. As you walk through this 9 steps, I know it's a lot for early in the morning, we're going to go through that with you today. And so I want to start with step 0. If you're an inventor, or even think you might be, step 0 is don't do it alone. I even wrote a book on this, but you're not alone. As an entrepreneur, it can feel so lonely. I know this as I started my own law firm. It's scary, right? But don't start your innovation, your invention process. Don't do it by yourself. Find counsel, find a mentor, find someone who can help you. In fact, one of my great mentors here, Elijah, says 1 + 1 = 11, and I couldn't agree with him more. So that's step 0. Step 1, okay, is this discovery calls. As you start to find the right counsel, the right attorney for your adventure, because this means so much to you, you want to invest that time to make not just one call. Don't just go with the first attorney, the first referral that you get. Make several. Make sure that it's a good fit for you. That means, is it the right style? Do they give virtual or do they require in-person consultations? Does your team need to meet with someone in a certain geography? Or can you really be represented virtually? That's an important discussion. And don't just take what you see on a website for granted. If this is that important to you, do the diligence on what those professionals have listed, right? Make sure they actually have a law degree. It's silly that you've got to go double check. Make sure they actually have your credentials and scientific, technical background about what your invention entails. Step number 2, legal consultation. To prepare for legal consult the best way, you want to make sure you bring what you've got, your invention, in the most complete form. In this consultation, you're going to answer on patent eligibility. Under 35 U.S.C. Section 101, that does your invention fit into the 4 buckets? Is it a machine or device? Is it a method or process? Is it a composition of matter? Or is it an assembly, which is a piece of lots of the things that have been out there before being put together in the first way? The next step, once you get through the legal consult, right, figure out, is it eligible? Is engaging with an actual law firm. And as an inventor, you should think seriously about, am I the only inventor or are there other inventors that need to have that consultation with me? And do I want to engage with that attorney on my own or as a business? It's a big decision to think about. And I strongly encourage you to think about a business-to-business decision of forming a company before you get engaged with that law firm to make sure you can engage properly. The 4th step in this process is the kickoff meeting. Once you have that initial step, working through an invention disclosure. And this can seem in depth or really complicated, but this is where you pour your heart out into written descriptions and the drawings and the prototypes, and you bring everything you've got to describe what the invention is. So that's the invention disclosure step. After that, it's patentability. So once you lay out what your invention is all about, it's now about, is this invention novel and non-obvious in the whole world? So in order to get a patent, you have to have an invention that is the first one of its kind ever. So that's researching all the publications, all the patents, anything that's ever been put out there before in the world, in print, in digital, and you have to prove to eventually the examiner that you have something unique and has a major impact. So your attorney will look over those results and give you the opinion and the answer to your question on, should I invest what might be 30, 40 grand, and the time and energy it takes to get it patent. Once you decide, that opinion will help make that decision. Now, it's not just about, do I have something innovative and brand new, but is it also marketable? I'll talk a lot about this with our clients, is hey, you might have the coolest badass invention, but if there's no one ready to buy it, you're not gonna have market success. And that's what we're talking about here today, is making money. So working together with your attorney and your own marketing counsel to say, okay, how innovative is it, and how ready is it for the market? And put both of those together is what will make patent success. All right, step number 5, hopefully I'm not skipping any numbers here, is the provisional patent application. You probably heard this term maybe if you watch Shark Tank, but a provisional is a less formal, quick way to do 2 major things. Get you a priority date, which is so important. The American Invents Act says, hey, whoever files first is going to get the patent rights. It doesn't matter who invented it first. So it is a race to the patent office. So you get that filing date, and then you get to buy more time. As an innovator, as an entrepreneur, being able to take upwards of a year to test your product, sell it, get customer feedback, That's how you make innovation that you can evolve into the step 6, which is the non-provisional patent application. It's a mouthful, I know, but that's the formal application that will get examined by the U.S. examiners at the USPTO. So step 7 is once you file that non-provisional. Okay, this is where you have to include the U.S. market, or if you're going to go for foreign countries, you have to include the application in those countries by that 12-month deadline. That cannot be missed. So the 1-year important deadline is something we need to make sure we advise clients on, and as the inventor, you should be worried about if you want to see market potential and capture the market outside of the US. So after you file the non-provisional, step 8 is called prosecution. So as the inventor, you should think about, okay, yeah, there's this examiner. Now I've hired this counsel, this team to help me draft and submit my application. Now it's up to this examiner, right? Their whole job is to make sure that nothing gets through the patent office that shouldn't, right? That's already been invented before. And they have their whole career in specific areas of technology. So for dental, right, if they have tools or devices, let's say, medical devices and equipment or tools, that's where that examiner spends their whole career. So they know all the history, all the prior and the current state of the art. So whenever you're submitting an invention, you better be ready. And unbelievably, no matter how much effort we put in, 90% of the time, examiners will push back and reject an application. And even though we tell inventors and owners of patents, hey, this is coming, the examiner's gonna push back. It's sometimes a surprise. So that is our job, our role as attorneys to help defend, come up with legal arguments, overcome and appeal the examiner's pushback. So that's step 8, is prosecution. On average, it's 2 to 3 office action responses. So it can take 2 years to get a patent through. So it's a long process and something you should be working through with your investors and your business partners to make sure you're thinking about timelines. Step 9, you've been waiting for this, making money. My goodness, okay, 2-3 years in this whole process. How do you make money with a patent, right? And this is done through enforcement, right? This is when you as a business owner are going into the market and you're selling your product. You can be the only one. You exclude everyone else in the market. You're the only one that can make it, use it, sell it, and import it. The other ways are through enforcement, right? Blocking up those infringers, okay? And that's done in federal court, at least threatening litigation, right? It can mean a lot. In federal court, through the Patent Trial and Appeal Board, and the International Trade Commission at Customs, so you can stop the shipments of illegal infringing products at the border. So thank you for your time. I appreciate everyone learning about patents in the morning and a 9-step way to move forward. But I encourage you to think about innovation, not just for dentists, but for assistants, office managers, and everyone in the office. Thank you.